Afternoon, Your Honors. The matter before the court this afternoon is a case entitled State v. Rheaume, case number 24 AP 202. Representing the appellant, Tate Rheaume, is attorney Sean Milligan. Representing the appellee, State of Vermont, is attorney Ian Sullivan.
Very much. I think I'm gonna. Video from it's not very good, so I'll let you know if I can't hear you. How's that?
Can you hear me okay?
I can, yeah. Thank you, Justice Cohen. Yeah, I can hear you fine, but I think I'm gonna stop the video. It's warbling. Okay.
And you'll just participate audio with the audio only. Is that correct?
Yeah, that's what I'm doing. Yeah.
Okay, great. Thanks, Chief.
So we'll hear first from the appellant, of course. Please introduce yourself, identify your client, and then proceed.
Absolutely. Good afternoon. May it please the court. My name is Sean Milligan, and I represent the appellant, Tate Rheaume. In light of the parties' briefings and this court's precedent in State v. Passano, 154 Vermont 377, there are really three distinct inquiries before the court on this appeal. One is whether the evidence of guilt is great without the use of the state's proffered expert reports. Two, if the court finds that the evidence of guilt is not great, whether the court erred in admitting the state's expert reports and relying thereupon. And finally, whether the trial court arbitrarily withheld its discretion by denying Mr. Rheaume bail, despite his compliance with strict conditions for 9 months before his arraignment on the aggravated murder charge. We submit that the evidence of guilt is not great, with or without the reliance on the state's expert reports, and that the court's decision not to exercise its discretion to release Mr. Rheaume is arbitrary, given the lack of change in circumstances during the 9 months he was released on bail, as well as several of the relevant factual findings underpinning the court's decision not to exercise its discretion being clearly erroneous.
Mr. Milligan, when it comes to the use of the expert report, it seemed upon my review of the trial court's decision, the factual components, that the court adopted Officer Dumas's opinion as a fact witness as to the actual speed of the vehicle upon collision. Do you agree with that, or do you think there was that I'm reading that too narrowly?
I do think that you're reading that too narrowly, Justice Cohen. I believe that the court's findings are based on a combination of the officer's lay witness testimony, as well as some of the specific granular details, i.e. speed, that were detailed in the state's expert reports. So I believe that the court's factual findings for weight of the evidence were based on the expert reports and the lay witness testimony from the officers.
And that would be, the lay witness's testimony would be as a fact witness, based on the fact that they're driving their vehicle at least Officer Dumas was driving his vehicle at the same speed or around the same speed.
Correct. Though we would continue our objection, as we did below, that really most of his testimony about what Mr. Rheaume must have been doing or thinking when he, at the time of the crash, is speculative. So I think that there's competent evidence upon which the court could rely on as far as Officer Dumas's estimation of his speed, meaning his cruiser, as well as his observations about what he observed Mr. Rheaume's vehicle doing. But I think that the court is limited to relying on that testimony to that extent. Before going into more substance of the claims that we've raised on appeal, I want to be clear about the applicable standards of review. One, for weight of the evidence, this court independently applies the Rule 12D standard to the record that exists below. As far as discretionary release, that is reviewed for abuse of discretion. The trial court's rulings on admissibility of evidence are also reviewed for abuse of discretion. And then findings of fact are reviewed for the clearly erroneous standard. I believe that all three of those standards are applicable to the issues raised on appeal, and so I wanted to make that clear for the record, as well as we are not renewing, for purposes of this appeal, our challenge on causation, as well as the aggravating factor number 3, other than we submit that the court should not have reached weight of the evidence analysis on the aggravating factors because the weight of the evidence on the underlying charge of second-degree murder is not great. So first, without use of the expert reports, the evidence of guilt is clearly not great. We do admit that the trial court recited the elements of second-degree murder correctly. However, it did not apply the mens rea elements appropriately. Specifically, the trial court found, quote, the defendant intended to kill the operator of the oncoming vehicle or cause her great bodily harm, and that he acted with a wanton disregard of the likelihood that death or great bodily harm would result from his actions. We would note that these are 3 separate mens reas, and the court never recites the definition for wanton disregard of likelihood that death or great bodily harm would result. There was really
Mr.
no...
Logan, the statute just requires one element of the mens rea because there's an or in there. It doesn't say you need to have all 3. It says you can do it there's 3 different methods you can prove the mens rea component of that statute. So all the state has an obligation to do is prove beyond a reasonable doubt one of those 3. Some judges may require that they elect which one it's going to be, or there'd be potential also for letting the jury decide which one of those elements it meets, as long as there's unanimity, correct?
That's correct. We would submit that really the state, when submitting the case to a jury, would have to elect which mens rea element it is electing to proceed on. But it is correct, Justice Cohen, that the court only needs to find one applicable mens rea proven beyond a reasonable doubt. But here, the court's analysis really conflates all 3. And again, most of the court's findings are based on some of the granular details that are provided in the state's expert reports, which we're submitting to this court was not admissible. Really, the court should have gone through an inquiry, an analysis of whether the evidence of guilt was great without the use of the expert reports before ruling on their admissibility and then relying upon them in reaching its final conclusions in this case. We also don't believe that the court's conclusion that Mr. Rheaume would have seen Officer Ebbinghausen's oncoming police cruiser and he would have seen blue lights and heard her sirens. This is based on speculation. And again, without some of the layout details that are provided in the state's expert reports, this is wholly speculative, which is really what the 12D standard is in part designed to is that a finder of fact is left to speculate based on the evidentiary presentation here.
Mr. Rheaume, how important is it the location of the accident? Not actually where it is, but that it happened in the right-hand lane of eastbound traffic while your client was traveling westbound. So the furthest to the right lane. So it's a 4-lane road, correct?
Yes.
And there's 2 westbound and 2 eastbound, and that this was the furthest of the eastbound lanes. Does that matter in this in the determination?
I think that it is relevant, certainly, for the court's inquiry, but that alone is not sufficient to find that there was a murderous intent, an intent to kill or cause great bodily harm in this case. Really, just the layout is one component of what's relevant to the court's inquiry here, and really, I think the timing, how quickly or not this crash actually occurred is all relevant to what Mr. Rheaume, my client, was able to perceive, understand, and react to in the moment. I would just like, understanding I only have 3 minutes remaining, I do want to pivot towards the court's exercise of discretion, or in this case, withholding its discretion, despite Mr. Rheaume's previous success of being released on bail for 9 months in between his original arraignment and his arraignment on the aggravated murder charge. I think it's important to highlight that this is not a case where someone was on conditions of release in another case and is subsequently charged with separate, unrelated offense. These new charges are based on the same conduct that was alleged, really at its core, back in July of 2023 when he was originally arraigned. There's an understanding that most people will comply with court orders when there's been a judicial intervention, and that's exactly what happened here for 9 months. We would also submit, as highlighted in my brief, that several of the court's findings regarding Ms. Hatch are clearly erroneous. We admit that it's a lot to take care of anyone on a 24-hour curfew, but she said she was willing to do it, and she had done it for 9 months. And we submitted the same schedule as was previously imposed on the condition 11 24-hour curfew, that Mr. Rheaume remained residing with her during the week. So in the end, I would like to reserve the rest of my time, but we do submit that the court's analysis was erroneous based on its factual findings, and it gave undue weight to the nature of the amended charge against Mr. Rheaume when deciding not to release him.
Okay, thank you very much. We'll turn to counsel for the appellee, State's Attorney Sullivan. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honors. My name is Ian Sullivan. I represent the state of Vermont. So the state and the defense agree about the structure of the court's analysis. That really we're talking about three distinct inquiries. One, whether the weight of the evidence is great without the expert analysis. Two, whether the expert analysis should have been admitted at this stage. And then three, whether there was an abuse of discretion in deciding Ms. Hatch was not an appropriate custodian. I'd like to start with what I believe is the state's most important argument, which is that the weight of the evidence of guilt is great, even without the expert opinions. And I think two of this court's precedents are quite helpful in reaching that conclusion. The first is State v. Burgoyne, which the state cited in its memorandum. The other is a three-justice memorandum decision, bail appeal that Justice Cohen and Chief Justice Reiber decided in State of Vermont versus Book, and that's at 2021 VT 31. I think the facts of that case are quite instructive when we are talking about the intent to commit second-degree murder. That was an attempted case rather than a completed murder. And as I read through the facts of that case, we are talking about a person in a vehicle that was stopped with police officers around them. The person was making comments to 911 along the lines of, somebody's going to get hurt. They're shooting at me now. Someone could get run over for less. And that the driving in that case came within about 12 feet of one of the police officers. At the trial court level, the judge found that the evidence of guilt was great for attempted second-degree murder, and this court affirmed. I think there are several factors that make that case analogous to the case that Your Honors are deciding today. One, the opportunity to perceive officers. Obviously, as in most cases, a defendant's mental state, what they are able to perceive, are frequently understood and construed based on the facts and circumstances around them. Here, we are dealing with a defendant who is navigating for some period of time from the initial interaction on Washington Street through the ultimate collision with Officer Ebbinghausen's cruiser. During that time, he was navigating through traffic, including through the parking lot of a convenience store, and was traveling, recognizing that that is one of the disputes, but traveling faster than the posted speed limit.
Mr. Sullivan, I'm going to ask you the same question I asked Mr. Milligan regarding the speed analysis that the trial court utilized here. You had two experts who had the speed 76 to 82 miles an hour, I think, in that range, and then you had Officer Dumas saying 60 to 70. Mr. Milligan thinks and I don't mean any disrespect to Mr. Milligan. I maybe sometimes read things too narrowly. So that the trial court tended to rely on the police officer's testimony regarding the actual speed that the defendant or the appellant was driving.
Yes, Your Honor, thank you. I believe on page 3 in the findings of fact, Judge Corsones relies on the speed estimate of Officer Dumas. Then on page 4, there's a recitation of what's extracted from the EDR analysis, as well as the calculations of speed. So I do think that both the officer's observations and estimates and the calculations appear in Judge Corsone's decision.
Okay, thank you.
Yes, thank you. And so in terms of, I'll just circle back to the opportunity to perceive, as Mr. Rheaume was proceeding eastbound on Woodstock, Officer Dumas was behind him. Officer Dumas was able to see the oncoming cruisers. From the opposite perspective, Officer Parker was able to perceive both the defendant's truck and the cruiser of Officer Dumas behind the defendant, leading to what I think is a straightforward inference that if from either side, the full scope of police cruisers headed one way, police cruisers headed the opposite way, with the defendant in the middle, mean that the person in the middle could perceive as far as the person behind him. I don't think that's a huge intellectual leap to go from those observations to the conclusion that the defendant was in a position to perceive. He also created a crash not in his lane of traffic. He had to go over a double yellow line into the oncoming lane of traffic. Certainly a vehicle, even traveling at the speed limit. Sorry, I might have missed a question there.
No, I think there was a noise of some kind. I'm not.
Yeah, I didn't want to cut someone off. Certainly a vehicle even traveling at the speed limit can do a significant amount of harm. I think those observations are clear both in the United States Supreme Court decision in Birchfield, as well as this court's decision in Boyea, talking about the immense amount of harm that can come from a motor vehicle. The decision to drive in oncoming traffic while there is a vehicle coming the opposite direction, I think quite obviously poses a significant risk that someone is going to get hurt or killed. And it is a fair inference for any fact finder to infer that a person's actions are their conscious object, that what they do, they intend to do. And that's exactly what the court did here in finding an intent to commit great bodily harm or an intent to kill. We believe that is an appropriate conclusion based on the facts that were presented, even without the expert analysis. I do just want to touch on one other piece of that, because when there is the opportunity to have calculations, sometimes there is a desire to fixate on those calculations. But when we deal with homicides committed by other means, whether it's a knife or a bullet or a baseball bat, all of those things, the manner in which the weapon is used helps understand the intent behind the actions. Nature and circumstances matter. The exact speed at which a bullet enters someone's body does not differentiate between homicide and an aggravated assault. Here, we believe the facts and circumstances support the intent. I want to shift, I recognize I don't have a ton of time, but I want to shift to the exercise of discretion. From our perspective, on a life offense case, having a custodian that is out of state, where a violation of conditions of release would require use of the extradition process to even get a person back, and under the Uniform Extradition Act, if the offense is punishable by less than 1 year, it would not be arrested by without a warrant prior to the extradition process taking place, meaning that just by the very nature of our laws, a person is under less supervision in another jurisdiction. I believe that concludes my time. Thank you.
Okay, thank you. Mr. Public Defender Milligan, let's see how much time you have, please.
Appellant has 24 seconds remaining, Your Honor.
Okay, counsel?
And with that time, I'll just respond to the state's last point. I think the strongest evidence that Mr. Rheaume does not pose a risk of flight from prosecution is that without extradition proceedings, without a citation, with only notice of hearing through counsel, he appeared for arraignment on the aggravated murder charge. That, in conjunction with the rest of the facts and circumstances before the court, should have led the court that he is not a risk of flight from prosecution, nor a risk of public safety. This court should reverse this decision.
Okay, Your time has expired. Thank you.